Hi, gu Hi, guys. I'm like, "Is this thing really working? Am I really on?" Okay, so I already hate this. Alright, so we are here on the Karen Reed matter. It is up for a hearing today. Look at this, my hair looks crazy. Um, on the motion to dismiss. Assuming that many of you know what's going on, but Karen Reed is accused of, um running over and intentionally murdering her police officer boyfriend, and the jury came back hung. After the hung jury, the defense attorney started hearing from several jurors that despite not reporting so and not having been asked, they had reached a verdict on 2 of the 3 counts, the first-degree murder, and the third, leaving the scene, um of an accident or leaving the scene of a crime for someone to die, and that verdict was not guilty. So the defense has filed a motion. Man, I really do hate this. Hi, all. It's so much easier, like, to hear another voice. I just feel like I'm kinda talking to myself. Um, so in any event, um, I guess what I'm gonna do is Um, I was gonna ask you guys to thumbs up and share again, but I don't know that I actually want you to because I'm probably just gonna bomb on this. But what we will do to start with, and of course, where I am most at ease, discussing the law. So let's just hop right into the motions. So I'm gonna start what I'm gonna do, and I know that we've done some lives and we've already discussed um, hmm, the motion of the state. I mean, the defense and the Commonwealth's response. So I'm gonna focus on the supplemental on the reply and then touch on the supplemental responses because from the reply, you get a feeling of what both sides have said thus far, and then how the defense is sort of countering that, at this time. So, hopefully, I can get to the right screen. Let's see if this works. Sorry, guys. Alright, alright, alright. So, before I do this, I'm gonna look back at my notes. So, I was working on this huge tweet, assessing the law, analyzing this from every angle. I have it almost ready to go, and we're at the True Crime Podcast Festival in Denver, which was amazing. I highly suggest anyone who hasn't done so to go next time. And I know in my mind I remember where the next one is, but I forget. But anyway, so I'm working on this tweet, and then I get this text from Bob about what happened at the rally. So after that, I didn't think it was appropriate, no matter which side of the aisle you are on, to be tweeting about the Karen Reed matter. Um, so in any event, let me stop saying about how in any event. Get back to seeing you guys, see what this looks like over here. And I'm gonna like I said, I'm gonna tell you what my initial thoughts were on the matter. Um, so, initially, most of my thoughts were that they needed to come at this also from another angle. Um, just about that there's insufficient evidence to like a backup to what if the judge decides that they didn't write it, it wasn't official, and she's not gonna bring them in to question them about their deliberations and any potential verdict they reached without having actually disclosed it. Although I do think there is the argument that the defense has made. It's it could work, it could be done, but I also see where the judge could just poo-poo it. So hopefully that's not what happens. Um, hmm, alright, I'm not gonna do this because I think I actually texted to Bob and and I can't go through all those. So we're just going to get right to this. So this was the defendant, Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. And that's, just typically the way it's done. Whoever the movement is, in this case, it was Karen Reed. They file a motion. The other side files what's called a response. And then the original filing motion files a reply. Um, Basically replying to that response. So now here comes Karen Reed by and through undersigned counsel and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute that, according to information from four deliberating jurors, it's now up to five, or more, I think 5, yeah. The jury had reached a unanimous decision that Miss Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Miss Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies, and they cite Green versus United States. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, i.e., the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. Rather, upon receiving the final jury note, the court sua sponte, that just means on her own, declared a mistrial with no warning to or solicitation of objections from the parties. Second, the jury note did not, quote, implicitly indicate an impasse on all charges. And that's a quote to the opposition uh, response from the Commonwealth. To the contrary, it was readily susceptible to interpretation, proven correct based on information received post trial from deliberating jurors, that the deadlock applied only to the multiple offenses included within count two and not to count one and count three. Now, I'm gonna say this even though I suspect most of you in here know, but I know, we could have people who aren't usually on our channel and are still somewhat unclear about, oh, the jury instructions, I'm sorry, the verdict sheets were confusing, they didn't know how to sign them. 1 and 3 were very clear. They are standalone, independent indictments, independent counts, and they just said guilty or not guilty. And in the state of Massachusetts, they can accept what's called a partial verdict, meaning they don't need to return verdicts on all the individual counts. And then where you get this question about did they know how to sign? Did they need some further instructions? They were confusing. It only relates to count two. However, the jury instructions, as we have discussed on this channel several times, they were either somewhat confusing or I guess it's better to say very misleading since the judge did not advise them after they were deliberating that they could move on from any count, any charge that they had. And this is again only to count two, um, to the charge defense onto the lesser included if they were at an impasse on the original charge. That didn't happen either, and the jurors were left assuming that they had to, I guess, come back with a verdict on all, and if they didn't come back on all, that was considered not having a verdict. Alright, so let's go back to this. Sorry, I'm flipping screens in here, and I just see that Disney Nerd 85 basically said the same thing that I just said. And guys, I'm not looking at the text because the chats, because 'cause I'm reading from the screen that I'm sharing. Um, Okay. Further and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all as contrasted to just some of the counts. Now, if you'll remember, Bob and I did a live where we played everything back. And while it's very true, the judge did not give them did not discuss it with them ahead of time, did not give them a moment to say anything. She dismissed the jury right away and at the same time declared a mistrial right away. Where and I think Bob might even be more hung up on this than me, although you know, identified it as an issue was, they did have some time afterwards and still didn't say anything. Now, technically, the case had already been dismissed and the jury had already been released. So, I mean, a mistrial had already been declared and the jury had already been released. So, the damage is done. And as we get into this, we'll see um that the state the the defense cites, again, cases that distinguish this situation, where the failure to object or the silence is not a failure to object. The underlying idea of constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, citing Green. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecution is entitled to one and only one opportunity to require an accused stand trial. They cite Arizona v. Washington, United States versus Martin Linen Supply Company for the quote, "At the heart of this policy is concerns that permitting the sovereign freely to subject citizens to a second trial for the same offense would arm government with a potent instrument of oppression. Thus, where the jury acquitted Miss Reed or alternatively was merely deadlocked on the relevant counts, the Constitution compels the same result, dismissal." I was wondering what when they say, oh, sorry, because I read that long. Read that wrong. I was like, "That didn't make any sense." Again, so thus, whether the jury acquitted Miss Reed or alternatively merely was not deadlocked on the relevant counts, the Constitution compels the same result, dismissal. Given the unambiguous post-trial evidence, it would simply be wrong to require the defense to obtain two acquittals from two different juries for the same crime. Now, this is kind of what I'm talking about, laying all their eggs in the basket of double jeopardy, because they could be making a due process argument. They could be indicating that there is insufficient evidence um, to allow the Commonwealth to proceed, and they could also argue the fact that the jury was deadlocked as something the trial court should consider in determining whether due process requires them not to be allowed to proceed on those counts. I wish I could be like, "Hey, Bob, can you talk for a second while I look for something?" Um, hmm, sorry, guys, just give me one sec. Hmm. All right. So, okay, this is what I was trying to look back at the notes because I wanted to remember something. If you guys may recall that Bob and I talked about whether the defense had made a motion to renewed their motion for a directed verdict of not guilty. And typically that's something that's done on the record. I did see a motion. I went to the docket and I did see a docket entry for the court having denied that. So the state did do that. The defense did do that, which now preserves that argument of insufficiency of the evidence that I was speaking of before. And based on my review of the law in Massachusetts, that they could file an appeal on the denial for that, and that's something that I thought, and it goes to, like, one judge of the Supreme Court. It's some sort of, like, mini thing that they do, and I thought that that's something that they should have thrown in here as well. I don't know if the time is told because they have this motion pending, um, but the argument that there was no manifest necessity revives her right against double jeopardy, um, which is what they're gonna get into here, and so this brought me back to Bob was is really strongly the mindset that they waived it, um, given that they didn't say anything, they didn't try to bring it up, and it does look like there could be room here for that, but again, I just believe it would have been best for them to kinda throw, um, another poker, another ground in there, something to the effect that the evidence was not sufficient to withstand the required finding of guilt unless it allows the court to find that there was some record evidence, however slight, to support each essential element of the offense. Further evidence is insufficient if it merely piles inference upon inference or conjecture and speculation, or if it equally tends to support either of the two inconsistent propositions. Now, you may remember that language. That is language that um, was it Alan Jackson? No. Yannetti asked to be added to the jury instructions, and the judge responded like, "I haven't used that language in forever." So you would think that maybe he was kind of looking at some of the, um, appellate case law or things of that nature. But I think an argument can be made that given the jury's finding of not guilty on those counts, that that does show that there is um, that it's reasonable for an inference to be go either way. Um, as could a hung jury make that same argument. So you kind of got to give them something to say, well, you've already denied it, Judge Canone, on the motion for a directed verdict, basically saying, no, she thought there was at least enough there to go to the jury. Basically, the argument I'm saying kind of raises that very same argument, but I think you could rely on even the hung jury, like I said, but definitely the deliberations to say, well, that supports the position that there are two reasonable alternatives here. And if the judge didn't think there were two reasonable alternatives before, the fact that the jury has come back hung on some and not guilty on others. So that's kind of where I'm going with that argument, that I would have liked to see something along those lines. In any event, going back to the pleading, I was looking at the time to make sure I'm not getting too close. The Commonwealth's leading argument is rooted in pure formalism. There's that no verdict was entered in the room in court. But precisely this formalistic mode of analysis has been consistently rejected in the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. And they cite to Ball, the reception of the verdict and discharge of the jury is but a ministerial act involving no judicial discretion. However, it may be in England. In this country, a verdict of acquittal, although not followed by any judgment, is a bar to subsequent prosecution for the same offense. So that's saying that if the jury said not guilty, even if the judge didn't enter a judgment, meaning an order, officially acquitting the defendant, it's still a bar to subsequent prosecution. That's from 1896. They go on to an 1981 case of Hudson v. Louisiana, holding that judicial grant of a new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize the trial judge to enter judgments of acquittal in jury trials. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising power to discharge a jury whenever it appeared that the Crown's evidence would be insufficient to acquit, citing back to Washington. Now, obviously, our law is based on English law, so that's why you are hearing, references to that in these cases. Um, And then they put in a footnote, the primary authorities cited by the Commonwealth in support of its position on this point are a pair of opinions from 1831 and 1878, respectively, neither of which addresses constitutional double jeopardy protections in any respect. Gosh, I just wish they would throw in due process as that backup due process argument, you know, independent of double jeopardy. And then they cite the 2 cases and indicate in any event, state law requirements are not binding on what constitutes an acquittal under the United States Constitution's double jeopardy clause. And then they cite, Massachusetts. And the same can be said in the reverse. The Commonwealth's heavy reliance on Bluford versus Arizona fails for the reasons set forth in the defense opening motion. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury was sent back to continue to deliberate. The four-persons report was not a final resolution of anything. There was no indication at the conclusion of the deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, 4 deliberating jurors attest that there was a final unanimous agreement that Miss Reed was not guilty of second-degree murder, persisting through the conclusion of deliberations. According to one such juror, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and count 3? And they cite to Alan Jackson's supplemental affidavit. Most importantly, unlike Bluford, now this is key, and we discuss this on this channel a lot about partial verdicts and the difference in the whole soft transition, all of that in Massachusetts. Most importantly, unlike Bluford, this was not a case where the defendant was charged in a single count which incorporated lesser included offenses. So again, count 1, 2, and 3 are single counts. Only one of them, 2, was a single count that incorporated lesser included offenses. Indeed, Arkansas law at issue in Bluford did not even permit the jury to return partial verdicts of acquittal. I didn't see them arguing this in their original motion, so this is good. It is a difference, and it's an important difference. Noting that jurors' options were limited to 2, either convict on one offense or acquit on all. Here, by contrast, the defendant was charged with 3 standalone counts. The state law expressly allowed for partial verdicts on any charges with respect to which the jury agreed. And they cite Massachusetts Rule Criminal Procedure 27B. Now, this is a rule that Bob's been harping on. He's talked to you guys about, he's tweeted about. In any event, it goes on to say only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. The lack of manifest necessities to support a mistrial provides a second independent basis for dismissal. So again, they call manifest necessity if the jury is a hung jury, that's a manifest necessity. But if there was an alternative and the judge didn't take it and they didn't let the defense be heard and the defense could have proposed one, those are arguments that there was not a true manifest necessity. While there is no doubt that a jury deadlocked may constitute manifest necessity, the Commonwealth, unsurprisingly, cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts. Contrary to the Commonwealth's characterization as ambiguous, and sorry I missed this footnote too. Um, it went back to when they were talking about the right here the jury's, position in his affidavit. The contrast with a juvenile v. Commonwealth case is even clearer. There, after the conclusion of trial, a court officer had picked up 4 verdict slips from the deliberation room, 2 of which reflected entries of not guilty. There was no indication as to when the entries were made or what circumstances, much less that they reflected a final unanimous conclusion of all jurors. I would have distinguished that differently because I sure as shit think the signature on the piece of paper mm, indicates um, that it was final. So, anyway, going back to the motion. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of mistrial with respect to all counts, contrary to the Commonwealth's characterization as unanimous, or is that unambiguous? The note at issue here was facially susceptible to 2 alternative interpretations. One, that the jury had reached an impasse on as to all charges, or 2, that the deadlock applied only some of those charges, example, on the multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves that the later interpretation was correct. The jury's failure to expressly mention its agreement on count 1 and 3 is understandable in light of the court's instructions that it, quote, should continue deliberating until it had, quote, reached a final verdict on each charge. And that's key. That's where I think the issue is here is not that the jury sheets were confusing, it's that the jury instructions were confusing or, like I said earlier, misleading in that regard. And again, we have discussed different charges that the judge can give after they've started deliberating, even though the Massachusetts has found that such instruction is fine pre-trial, pre-deliberation. At some point, the court should let them know that, well, you can bring back a partial verdict. Given that there was no deadlock on 2 of the 3 counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those charges. The defense does not suggest that this court was required to give the jury new options for a verdict, only that it should have asked the straightforward question of which of the separate indictments the professed deadlock related to. I would have thrown in there an argument that as to 2, the judge could have given further instructions that they could move on if they did not agree to the offense charged and start considering the lesser includeds. But I mean, that's way lesser of an issue than where we're at right now. In essence, the Commonwealth's contrary position asks this court to close its eyes to possible, or even, as here, very likely, existence of partial unanimous verdicts on some, but not all, separately charged counts to avoid the risk of juror coercion. And they're quoting Commonwealth v. Ross. The Commonwealth utterly fails to acknowledge that Roth, Bluford, and a juvenile are all clearly distinguishable because they all arose in the context of lesser included offenses contained within a single charge. Again, that's what we've kind of been saying from the beginning. They could have signed the verdict sheet on 1, signed the verdict sheet on 3, and, you know, been undecided on 2. The Roth court's concern about coercion makes sense in that context. When the jurors report a deadlock on one charge, follow-up questioning regarding the possibility of reaching a verdict on a lesser included would simply imply the jury should consider conviction on that lesser offense. But this logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires this requires judges to disregard the possibility of a partial verdict, where the verdicts would be on standalone separate charges such as those in the current indictment. Mm. And then they cite the rules that allow permitting taking verdicts on uh, less than all the charges. That's that rule 27B that Bob spoke about a lot. Then they cite a juvenile v. Commonwealth, where a complaint or indictment in multiple counts charges multiple crimes. A general verdict could be returned as to one of the counts despite deadlock on the other counts. And that's them saying that that's essentially the same as a general verdict and not really a partial verdict because it's dealing with the separate counts. Now, Bob, this is the exact reporter note that Bob's tweeted about and been gung ho about. Mass Rule of Criminal Procedure 27 reporter's notes, providing that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. So again, it's the reporter's note. It is persuasive, and it's not exactly obviously it's not as clear as the rule itself, but glad that they've now cited that. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to the single question of whether its deadlock is on certain but not all counts, or if it has reached a unanimous verdict on any counts. And they quote Commonwealth v. Foster, affirming the trial judge taking a partial verdict on 2 of 4 separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant into final ones and to abandon all doubt that have privately entered I'm sorry, may have privately entertained runs counter to the clear instruction of the judge and amounts to mere speculation without any proof, without any support in the record. They also cite a 1992 case, Commonwealth versus LaFontaine, affirming partial verdicts taken after the judge asked the jury whether it had reached a verdict on any of the indictments. So we're saying there's no pressure from that. It's not coercive. It's a simple question. And that's countering the argument that the Commonwealth made that what the defense is asking would have been coercive. And they used cases that didn't have standalone separate indictments to make their point. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. Also quote Cruz versus Commonwealth, 2012. And the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when a defendant is actually acquitted. Commonwealth's proposed rule would also undoubtedly hinder law enforcement's interest by precluding courts from asking whether the jury may have reached a guilty verdict on some but not all standalone counts. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense request for a Tui Rodriguez instruction. So this is the defense countering them. They're like, "Hey, just because we asked for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial." I 100% agree on that. Could not agree more. A discussion with counsel, such as that occurring twice earlier in response to jury notes, and either the consent of the defendant to a mistrial or further judicial inquiry of the jury instead was required. It is undisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of the Tui Rodriguez instruction. In short, mere silence, absent the opportunity to object, does not amount to consent. And they cite back to their original motion. The cases relied upon by the Commonwealth are readily distinguishable on this basis, or even support the defendant's position. They cite Commonwealth v. Fetsaya, I don't know, 1996 case holding that where, quote, the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial. That's what happened here. The lack of an objection from defense counsel cannot be construed as consent to such action. Compare Commonwealth v. Curtis, 2002 case. The judge declared a mistrial upon the defendant's request. In Pellegrin versus Commonwealth, the 2006 case, finding that the defense plainly had the opportunity to object, where the mistrial was declared after a voir dire and a colloquy after the jury were cleared from the courtroom. Here, she did both at the same time, right in front of the jury. Didn't give them a chance to object. Let's see. Hold on one second. All right, going back at it here. Wait, sorry, wrong screen. In only one case cited by the Commonwealth, Fuentes v. Commonwealth, 2007 case, was the defense, as in the present case, afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly, quote, stated that the jury could not reach a unanimous verdict as to either of the two indictments. Wow. So the Commonwealth cites this case disingenuously without providing, we have a duty of candor to the court, not to basically misinform, leave out the factual basis of court opinions that are contrary to our position. So, I mean, that's, and I'm sure that maybe they make an equal argument somewhere as to the defense, but that's kind of a big one. In those circumstances, while the most prudent course would have been, and now this is even in the case where they sent out a note saying, we can't reach a verdict as to either. So anyway, the court goes on to say, in those circumstances, while the most prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied to all counts, and it is patently clear from the affidavits submitted in support of defense motion for that consultation with counsel may well have produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on all of the 3 counts, which, according to the information from jurors A, B, C, D, and now E, would have resulted in acquittals on counts 1 and 3. In any event, Fuentes did not alter the court's clear obligations repeatedly reaffirmed since that decision before declaring a mistrial. 1, the court must have given a full opportunity to be heard. 2, the trial judge must have given careful consideration to alternatives to a mistrial. Citing Ray v. Commonwealth. Oh Lord, we're only on 8. I better keep an eye on the thing. This thing's like about to start. Where's that? All right. Go back to it. I have that screen open. The Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon the information. The jury's agreement that Miss Reed is not guilty on counts 1 and 3 reflect the results of its deliberation process, not the contents of jury deliberation or thought processes of the jury. Now, that's important because it's very clear that you're never allowed to bring in the jury to ask them, "Well, what'd you guys talk about that back there? Did you consider this? Did you consider this? You tossed this around?" Um, oh, hold on one sec. My lord, I hate this, you guys. I don't know if I'm watching the screen anymore, though. Okay, got it. Got it. I think. Still says 1 minute. Okay. And then they cite Commonwealth v. Cassidy, a 1991 case, remarking that the trial judge was rightfully loath to examine the entire panel to attempt to determine the impact of the errant juror on the rest of the jury. Again, they that's like a different situation. So it's good that they're trying to distinguish that. Although you're also not supposed to be challenging them to change their verdict, but this is not exactly that. Obviously this situation does not come up very often. So, you know, all arguments are at play, including due process arguments. Oh God, he's here. Thank God.
Are you keeping an eye on the court?
I am. I have it up. I'm just like butchering everything over here. I feel
sure
like I
you're
bored
doing
everyone out of their minds.
really doing amazing, you guys. Tell me. I'm sure you're doing an amazing job.
Well, let me finish these last
in lieu of
couple
like missing
sentences.
the beginning of it.
No, I have it up.
Okay.
But here's my question. Well, I guess you can do it now, so it doesn't matter. But like, how would I know when it starts playing? Like right now, it says "Waiting for Long Crime Network." Like, I'm assuming we'll see that.
Wait, somebody said in the chat. Hold on.
Well, you figure it out because maybe I'm doing it wrong.
Let me see what's up.
I had Long Crime up.
Let me see what's up.
Seems like people are talking. How do you play? Am I doing something wrong?
Hold on. I want to. This is why I was. That's why I was asking Dizzy to help, and then you said, "We got this, babe." Making me feel bad.
We do, but I'm also not paying attention to. I mean, I don't see it on my screen. It says "Waiting for Long Crime Network."
All right.
Well, double check.
Is it on trials? Do you know? Let me see. Might have to go to. Let me see. Young Dog Witchcraft. No.
I don't think it's happening. I could pull up the Zoom, but
you might have to go to 10. Let me see what they're
I'm
saying.
pulling up the damn Zoom.
Oh, the court Zoom?
Yeah.
I think that's always safe. Uh,
That's not where I was.
let's see. Is Dizzy saying anything in private? Isn't
I
live.
checked my phone.
Dizzy says, all right, let me see. Karen Reed's status hearing on Monday. Are they calling it a status? Really?
I mean, for all we know, we get here and
All right, I'm going to go to. Let me see what the hell they're saying here.
oh, here it is. I'm gonna there. I'm getting it up here. If I can remember where it was.
See, Jackson's. All right, they're up. All right, so I'm pulling it up. Wow, it's been up for a while, dude.
What? Well,
All right, don't worry. Not that long, like a couple minutes. All right, so I'm pulling it up. It's on 10. I'm going to Boston
Jesus.
10. It's all right. It sounds like they're gonna give a status and she's gonna give a date on the other thing, is what it sounds like to me, if I had to guess. Right. Uh, okay, Diz, can you make our screen block shit, please?
I'll be right back.
Okay. All right, so I think this is the beginning.
I can't hear shit. Hmm. There's no sound, babe.
Wait, what?
Jesus. No. Just rewind it.
You guys are not hearing it?
No. You want me to do it? What are you watching this on?
Fine.
Long Crime? Can't really hear you that much either. But now mine's up. Jesus.
So no one's hearing this?
Alright, I'm gonna play it. So you can stop sharing, as I don't know what's going on over there. If anybody's even staying with us, we're, like, super behind time.
All right. First of all, we haven't missed shit all the time except like set trial date. The
Okay,
hearing's
hold
not
on.
going today.
Your sound is weird, like, I can't even hear you talking into the
It's because it was from.
Oh, now it's working.
It was always working, honey. It was.
Alright, here we go.
I can't do that. Okay.
Rewind it.
3 weeks Superior Court trial and jump into this case. I can't do that.
Make sure I'm not set up.
Okay,
It's like a default.
so what are you telling me? You just said you're willing to make this a priority, so we'll stick with the 27th?
So get rid of the chat.
Well,
Next
How
off.
do I
why don't we do this? Let's put it on for the 27th. Let me see if I can make it.
Full screen down in
I'm
the.
doing it,
And
hold
then
on.
on the next day,
Oh, all the way.
if I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy, who's the garage up there about this.
It's yeah, okay, that's great.
All right, so let's set it for the 27th.
Can
And
you go back
why don't
further?
we do the 14th
No, that's
for
where it started.
final trial conference?
Why the hell wasn't I getting signed here?
At the 14th at 9 or 2?
2.
It's like,
If it turns out that we have, in excess of 35, whatever motions eliminate still at that point, let us know and we will try and get a little day.
he doesn't look happy.
All right, thank you very much.
Thank you.
What? That's all that happened?
No, I keep trying to explain to you that you can't rewind. It was 20 minutes long. So
This is where it started for me.
Oh, so like no, I went to CBS News Boston. That's what I was watching, and I have no idea. I'm sorry, y'all. I didn't see in the chat that the sound wasn't working. I don't know why it wasn't. It was I mean, it was a StreamYard thing, not a Bop thing. Like there's sometimes when I put it up, but this has the whole hearing. So let's try to figure this out. It was very short. It's like 5 minutes long. She didn't handle anything.
Well, I have it.
But what I have it up, like I don't know why there's no, because I don't have this muted. This particular.
I'm not seeing you got to send me the link because.
Just go to
Oh,
CBS News.
this is it.
Yeah.
Oh, you have to click that sound button at the
I
bottom.
did. It was.
All right.
Like I'm telling you, it was nothing I did. It was
All
like.
right, I'm doing it.
All right.
Doing it. Calm yourself.
I'm calm.
I know you are.
That doesn't help.
Boy.
Me, by the way.
Okay, I'm assuming this is it, but I have no idea. So
defense
started
team
like this.
is asking
No.
to throw out.
I don't know. You have to send me the link.
All right. Let's see if you guys can hear it now. Can you hear it?
Yeah.
Good afternoon, Your Honor. Martin Weinberg.
This is the very beginning.
Good afternoon, Mr. Weinberg. It's nice to see you.
Good afternoon, Your Honor. Dina Ginetti for Karen Reed.
Good afternoon, Ms. Giannetti. Good afternoon, Ms. Reed. All right, so the case is scheduled today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be with your schedule. Then we need a trial date, and we need a final trial conference. So I was thinking on the motion to dismiss, can we do it a week from Friday? It would be for oral argument only.
From the defendant's perspective, yes, Your Honor.
All right, I think that's August 2nd, Mr. Clerk.
I'm gonna be out of state. I return on August 3rd.
Okay.
I'm looking back through the comments now. I love you, but is Bob joining?
Are you available, 2 o'clock, are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument only, okay?
2 p.m.
2 p.m.
And that just means she's letting them know
The schedule, and I
she's
assume
going to decide if
whatever
we'll bring the
I
jurors.
end up doing on the motion to dismiss will be appealed. In an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th.
Well, they need to complain. It's too close
The
to.
Commonwealth
Oh no,
available?
sorry, it's right after Christmas and New Year's.
That's fine. Your Honor.
It's perfect time.
Okay, Eddie?
That should be fine.
Okay, so January 27th for trial,
Never want a long trial in November and December.
and let's do the final trial conference the week of the 13th or even the week of the 6th.
If no one wants to go.
Do you have the calendar, Mr. Clerk, or any of those days?
Yeah, there's nothing, just not the 9th or the 16th, but all the days are open.
Okay.
Your Honor, the only caveat, I don't have anything on the 27th. I'm clear for that day, but for the fact that I have a Superior Court trial scheduled to begin in Essex County on January 13th. There are multiple.
How long do you expect it to take?
That's what I was getting to. That could take longer than 2 weeks. I'm happy to have this case take priority over that, but that's.
No, we'll hold it for you day to day if need be, and I can contact the Essex Superior Court judge once you know who he or she is.
Yeah, that's not ideal. In terms of preparing for trial, I can't do 2 or 3 week Superior Court trial and then jump into this case.
I can't
do that.
either. It's
Okay.
that the struggle is real.
So what are you telling me?
Some judges call
You just
bullshit.
said you're
Like
willing
when
to
you say I
make this a
can't go
priority,
like
so we'll
from
stick
one
with
trial and then
27th?
two. Like I've had judges want me to go the next
Well,
week, and I always say at least a week
why don't we do
between,
this?
and that's on a
Let's
normal.
put it on for the 27th. Let me see if I can make peace in Essex County. And then on the next date, when we come back for oral argument, if I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy, Mr. Raj up there about this.
It's okay, that's great.
All right, so let's set it for the 27th.
I mean, Taryn, you gotta
Why don't we do the
pick our
14th for
battles, but I hear
final
what
trial?
you're saying. That would take out like
The 14th at 9 or 2?
we'd be in Easter time.
If it turns out that we have,
Not
in
the
excess of 35, whatever motions to eliminate still at that point, let us know and we will try and get the whole day. Okay. All right, thank you very much.
Thank you, Your Honor.
All eyes support, please. Meet down at 2 p.m.
There you go. Short and sweet. Nothing. So trial date was set. So
Right.
So if
So
you
wait.
guys, yeah.
I
So-
think I should finish reading the last couple sentences of this motion,
pull it
and
up.
then we can get to talk about whatever. And we were literally at the very end, you guys. So I just want to read it, and then we can talk about the supplements where two more jurors came forward.
People were tweeting at me that they couldn't hear it.
Yeah, because they know that that's why you're not looking at the chat. All right. So we were talking about how you're not supposed to bring the jurors in to delve into their mind of what they were saying or thinking during deliberations. So the defense is not relying upon jurors to attest to any particular statement made or incident that occurred during the jury's deliberations, the effect of anything on any juror's vote or any juror's mental process concerning the verdict. And they cite the Mass Rules of Evidence 606B. Rather, the defense is relying upon the simple fact that the jury's agreement that Miss Reed is not guilty on the relevant counts. Again, citing the rule that permitting juror testimony that, quote, a mistake was made in entering the verdict on the verdict form. That would be something we'd see. Oh, no, I was just going to say that would be comparison. That's what that CF means. It means, hey, this rule doesn't say exactly what I'm saying, but compare it because it has some,
Oh,
it's similar.
hold on. Jay, jump on, dude. Let's hear it so you can give
Wait,
us an update on Adelson and we can guide people over because
I thought he
ours
didn't
short.
want. Mm.
I think, well, if Jay's off, Jay sounds like he's off too.
Right, but I thought he didn't want to do Reed, and now you're trying to
That's
switch
right.
over to Adelson before he can hop on when we're done, but we didn't even tell them about the jury's things or
Okay.
I'd love to have Jay on if he wants to come on.
Wow, could have fooled me.
Right, no, I just didn't want you to
Sounds like
completely
I
shift.
would have loved to have Jay on.
No, I just didn't want you to
Sure.
shift right away to Adelson, but if he's happy to come on while we're talking about this, I'd love to have him. I always like his to see his face and to have his personality, mixed in here with us always.
All right, enough brown nosing. Keep going.
No, but I just wanted to.
Pulling an Allison right there. That's
All right. But you know what I really meant.
I do.
The permissible subjects of juror contact listed in the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing the fact of a jury verdict constitutes a, quote, prohibited subject under Rule 3.5c. Again, they're talking about asking the jurors about their verdict. At the same time that the Commonwealth criticizes the defense for purportedly infringing upon the jury's deliberative process, it also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in the Commonwealth v. McCallop, and that's a 2020 case, attesting to alleged juror bias was no less hearsay, and the Supreme Judicial Court squarely held that entitled the defendant to further inquiry on the subject. The defense submits that the same result is warranted here. And then they asked that it be granted. So real quick, I'll just
Was that the supplemental or was
no,
that?
but before I jump over to the supplemental, I just want to say, look what they cited right here, babe. Oh, it's gonna make you happy.
Mhm.
Oh, I wanted to see who signed this. Was it the new lawyer?
Yeah.
So yeah, there you go. You got some, but that's where we talk about appellate lawyers really digging in. So that's why you've got some sort of more legal arguments than we saw in the first. But oh shit.
Yeah, I mean, Weinberg, they had to get a new lawyer, just so you guys understand, because unequivocally, Yannetti and Jackson are going to have to testify. However, interestingly, which when we get to the hearing, which I think we should just go through the hearing and then just in case people missed it. So essentially all that happened today, if y'all are late, dates were set. So trial date of January 27th, 2025 is set for the new trial. And then they set a date earlier in January for final pretrial hearings, where again, they'll go through all those motions in limine, which we saw in this trial the week preceding the trial. So that voluminous list of motions in limine about what's going to be allowed in, what's going to be kept out, those things, that's going to take place. I think they were talking about the January 9th or 13th, one of those 2 days. Don't quote me on it, but it was earlier in the month. And then as far as the defense's motion to dismiss, that was set, I believe, for August 9th, 2024 at 2 p.m. for oral argument only, which means that there will be no witnesses testifying.
Right. It's to decide whether there will be witnesses testifying. That's all. That's the first step. You don't just obviously bring the jury in.
And the most telling aspect of that is that she brought up leaving plenty of time for appeal.
Right. And that plays into what I was mentioning earlier, that I thought they should have basically argued that a due process issue and insufficiency of the evidence based on using the hung jury, plus the fact that multiple jurors are saying that they were had a final decision of not guilty on these counts shows that there were those two equally reasonable interpretations of the evidence, and that the court should reconsider that decision, and then they should appeal that too. So this I wanted you to see. It's that note to the reporter's note of the Rule 27.
Yep. That the
Yep.
court made it right.
So
Yeah, and I kept having to explain to people, I'm like, that's a note. It's a reporter's note. That's not the rule.
right.
You know, like they put notes in on cases just so in order to be instructive about how other cases have handled it, or it's been construed in other cases. It's not the rule. So people, because there was conflicting language.
I explained it to them. Yeah.
Yeah, it was like there was a lot of tweets going out. I'm like, man, I'm like, people just aren't reading what I'm writing. It's not,
You know, I was thinking about it, and it's just like certain people, like, for example, when I put out, like, I think that the jurors' names should, remain impounded. It's like they hear a certain side of something and just think that that should be the other side, not their side or whatever, and don't actually process, what is being said. And it's like the same thing when they're, um, hearing about rules, and then might be other people kind of telling them something different. So, all right. So the first supplement, now this is a fourth deliberating juror. Juror D confirmed that the jury reached not guilty verdicts on counts 1 and 3 once they were dismissed, and many of the jurors appeared uncomfortable with how things ended, wondering, is anyone never going to know? So it's the same thing they cited in the motion. Juror D told counsel part of his or her discomfort was that he or she knew that the jury had reached verdicts on 2 counts and Karen Reed might be retried on those counts. And that's just not right. Juror D further stated, every one of us will agree and acknowledge that we found Karen Reed not guilty on counts 1 and 3 because that's what happened. And then they attached the affidavit. I'm not going to read you the affidavit because all the good stuff was right there. And now you've got a fifth deliberating juror, to Jackson again, confirmed that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. And then they, ask for the same relief. So, now what do you guys want to talk about? What questions you want to answer? Where were you about to go
Hey,
that I
Josh,
was like,
gonna pop on with us.
who is?
Josh Ritter.
Well, you made the offer to Jay, right?
Of course, I made the offer, a tweet to both of them. So Jay, I don't think has too much interest in jumping in on this, which I respect. Josh, he's happy to jump on because.
So in the meantime, Anaya.
Well, let me
Ask-
ask you a couple questions, babe.
Okay.
So let's assume, and I've put this prediction out there, and it's not what I think should happen. It's what I think will happen. I think that Judge Bev is going to deny the motion to dismiss. I don't think that she's going to get to the merits. I think that she's going to find that they waived the issue because they failed to object. And she's going to double down on the concept that not only did they not object and request that she inquire of the jury as to whether or not they were deadlocked on all 3 counts, but that they were the ones asking for her to declare a mistrial. I think those 2 things are going to play against. Oh, good. Here's Josh.
Well, at the time,
Hey,
Josh.
hi guys. How are you?
We're
Good.
awesome. How are you? How did it
Very
go
good.
over in Adelson? Was it short and sweet like this one?
Yeah. Well, not as short as this one. I was shocked that this one didn't last much longer. So I'm guessing they didn't argue anything. But yeah, it was just setting dates. And the one interesting thing that came out is the defense attorney said that they're going to make a motion to change courtrooms for the trial, which made me think of Karen Reed.
Yeah.
I said to myself, since when did attorneys get so picky about the courtroom?
Maybe it's camera angles. That's my dad's side.
No, it's got to be jury
dad's
box.
side.
It's got to be
angle.
lighting. The lighting is not as
That's right.
Flattering in that courthouse.
That's for sure. That's for sure. So Adelson still on track for trial?
Oh
Sounds
yeah.
like-
Yeah.
Okay.
No, they're heading full steam ahead.
All right. Yeah, I was I guess, when they brought what's his face on, who is it? Rosenbaum? What's his name? Um who's the guy? Who's the former lawyer for Charlie?
Oh, right. Charlie's former lawyer is the new attorney. Yeah.
Well, yeah, I think he's second chairing it because like when the trial date was set, and I was telling Jay, I was like, "Oh yeah, Roshbaum, thank you, Jay." I'm like, man, like that's kind of a quick trial date. Like, don't be surprised if it's continued because that's just kind of par for the course. They'll set that initial trial date,
Right.
especially when it's the first date set after she's arraigned, right? So like it's par for the course for those things to get kicked. But then when they brought Roshbaum back on with them, I'm like, all right, well, that expedites things for the defense because he's like a wealth of information in terms
Right.
of what the state is going to be presenting at trial in terms of against Donna. So yeah, that's one of those things where I can see how maybe they're still on track. Here, Josh, all that happened, they set a trial date for January 27th, 2025. Pre-trial hearings, motions in limine, I think are a couple of weeks before that. I didn't catch the date exactly for what they set that for. And then the motion to dismiss for oral argument only is going to be set for August 9th at 2 p.m.
Okay.
This year. So that was it.
So,
that was done.
So Rami, and thank you very much for your generous $50. $50 holla. Is that good, babe?
Yes. Thank you.
It says that Christina Rex, a Boston journalist, spoke to a juror F2F. This juror, what does that mean?
Face to face.
This juror confirmed not fully on 1 and 3. So, I'm surprised because they then use the word soft decision of 9-3 guilt on count 2, that they didn't use that language as to 1 and 3, because that's what I thought the Commonwealth might argue, that it was a soft decision. It wasn't like formal, vote final decision. Anyway, he goes on to say, this juror, according to Karen Reed, spoke about the jurors being confused on how to communicate this. Well,
Communicate what? I'm confused.
right, exactly. Based on this, what he or she is saying, there was nothing to communicate because
They weren't unanimous.
and it wasn't a final decision, and they were all soft. We'll have to look into what Christina Rex actually said. Maybe it's being lost in communication.
I'll check.
But I can tell you, so I was starting to tell everybody earlier when I was on alone, and I'll tell Josh, and that's Courtroom Confidential, right? It's your channel?
Yes, ma'am.
Courtroom
Confidential.
Confidential.
Check it out. Yeah.
Check it out. That I had been working on, like, researching and, like, coming up, like, on the defense's, motion for this while we were at the True Crime Podcast Festival and right around the time that everything went crazy at the Trump rally. So I never actually did anything with it. I was going to make a post, but anyway, so I was thinking after I looked at everything, like my final and be all decision was that I thought the defense should file a combined reply to the Commonwealth's response to motion to dismiss and a supplement to their motion to dismiss seeking alternative relief. Therein, the defense should ask to bar the retrial on double jeopardy grounds because of insufficiency of the evidence, or alternatively, to have the charges dismissed because the prosecutorial or police misconduct that occurred during the trial, as far as the inverted video, all the things that you could argue under Massachusetts law, where mistrial is declared because of a hung juror after defendant moved for a finding of not guilty. Common law double jeopardy principles entitle defendant to a review of the legal sufficiency of the evidence before another trial takes place, during which the court must decide whether rational trier of fact could have found each essential element of the crimes charged beyond a reasonable doubt at the first trial. If not, retrial of the defendant would violate common law principles of double jeopardy. And that was and I saw like a 1998 case that sort of supported that. So I thought they should actually, throw in due process,
Yeah.
just in addition to double jeopardy. Um, and I thought that they should ask for that hearing. And I think, Bob's argument was, well, she denied a directed verdict. So how's this any different? But, they did say, like, at this hearing that evidence will not be sufficient to withstand defendant's motion for required finding of not guilty unless it allows the court to do more than find that there was some record of evidence, however slight, to support each element of the offense. Further, evidence is insufficient if it merely piles inference upon inference, so just like that the Yanetti's jury instruction request, or conjecture and speculation, or if it tends equally to support either of two inconsistent propositions. And that's where I thought they could use the jury's verdict not to have a second kind of way other than just double jeopardy to
Divide the
say,
apple. Yeah.
right, to say to the judge, well, considering that they did have these not guilty, or how long deliberations took, or even just if the jurors said nothing and it was just a mistrial, same sort of argument, how lengthy deliberations were. We've seen the courts consider that, and they're coming back hung. Well, that supports that that there are two, equally possible propositions that are equally inconsistent, even if the judge didn't initially, think that's something that should be reconsidered. And also just to throw in due process on, like I said, the prosecutorial police misconduct, just to kind of put something out there if something failed on due process grounds, because yes, you're going to get that opportunity to appeal. Don't pass an opportunity to kind of throw something else out there. But there's more legal minds deciding what to do, on this over there than my quick assessment of everything. But that's kind of where I thought the defense should have gone.
I don't know. I mean, it's such. I've never seen a situation like this. It sounds like
Never.
most people I'm talking to have no idea exactly how. There's
My
no,
initial
not like a
instinct
bunch
was
of
like,
case law on this whole thing. I mean,
right.
I think you're right. I think you kind of throw everything against the wall and see what might sticks. That one question I had, I was talking with some friends of mine who were also previously prosecutors, is okay. So we all agree that they probably have to put, these people have to sign either affidavits or come into court to testify, some of these jurors. But how many of them? Do you have to get them all to come in? Is it enough if you've got 5 or 6 of them that all are saying the same consistent thing?
What
Or do you
I
feel
think
like you need to get all 12 to actually come
We
back?
got to get all 12.
So I think what should happen is the judge has this first hearing without, and this goes to Anya's question, that the first should first have a hearing on it to determine whether she even wants to hear from the judges. And again, that's why I think other reasons to hear from them over and above just double jeopardy grounds could be thrown in there. If she decides it warrants at least a hearing, you bring in the ones that are willing and not, like happily willing to come in and hear from them that they're subject to cross-examination, that this wasn't soft, it wasn't, it was
Right.
final. And then if she's satisfied that based on what they're saying, that there's uniformity amongst them, at least, that it was all of us and it was firm and it was decided and we kept it till the end, that then she does exactly what Bob just said. Then she brings in all the jurors and the judge questions them, like outside of the lawyers, not subject to cross-examination, just, with
And
either the court.
can she even do that? I mean, does she even maintain jurisdiction over them at this point? They've been released. They could say, I don't want to hear from you people ever again my whole life.
Well, they do. I did look, and they do have post deliberation voir dires for things like was there, information outside of the jury brought into the jury room? Did someone in
Misconduct
the
or
right,
something.
on misconduct issues? Obviously, they don't let them in to challenge their verdict. They don't let them in to ask them what were they thinking during deliberations, not their actual deliberations, just did somebody bring in this information they heard from the internet, whatever the case may be. Did you talk to someone on the street and then did you tell the rest of the jurors about it in the deliberation room? So again, like you're saying, there's not a lot of case law like this, but
No.
the defense did a good job of trying as best they could to distinguish challenging a verdict and inquiring into their mindset during deliberations from what they're asking to do here, which is just, did you have a final vote? Was this your final decision at the end of things there? Now, what I think is going to be hard is even if it was, you might have some jurors who don't want to say that anymore,
Right.
you know?
Right.
And that'll be an issue when they bring them all in, and that's why you think, well, I don't want it to be just the judge there, right? I want to be there. I think what she should do is probably have them in the room, but that they don't speak, and then they have a way to pull the judge aside and say, I want you to ask this, or to hand the judge a note, I want you to ask this, because obviously the judge likely would not probe beyond that, to see, well, is that you changing your mind now? Like when you were really in that courtroom, how did you feel about it?
Yeah.
Maybe they go over ahead of time some preset questions the judge is going to ask. Both sides have influence. Both sides put questions out there. I mean,
I
I
love
think
you both, but I'm going to jump in right here. I think you're putting the cart way before the horse. Like Allie, you were assuming that they're ever going to get to this.
well, I know I was saying if.
Right. So, because what's going to happen here, I'm just telling you, like you can just read the pleadings and you know what the issues are going to be. Canoni is going to deal with the two issues of one, did they waive it by failing to object? And this concept that they didn't have time to object is bullshit. They had all the time before the jury was walking into that room to either object or to request the judge to inquire of the jury whether or not they were deadlocked on all three counts. They had all the opportunity in the world to do it then. They had the
They wanted to
opportunity
hang.
right. They had the opportunity to object after she declared the mistrial. Like I was saying, like we don't wait. We don't wait. We're not waiting for, we're not raising our hand when we're objecting and saying, waiting for the judge to call on us. This isn't a classroom. This is a courtroom. And we have to preserve, we have a job. It is our duty to protect the record, to protect issues for appeal for our clients. It's our duty. We've taken an oath to do it.
Right.
They didn't do it. And beyond that, they still had time after she excused the jurors. They left. Yannetti was texting instead of that. It's like, and I'm not casting shade on them. Like in that moment in time, I think Allison and I, and probably you, Josh, you're feeling like it's a win, like a Mistrial very
100%.
feels like a win right there. So you're not necessarily thinking of it like that. But the problem is going to be that it's giving Canoni a place to hang her hat legally to where she does not need to get to the merits. She does not need to get into this seemingly like just swamp of legal issues where like no one knows what
It's an easy out.
Exactly. And beyond that, they asked for it. She's got two things. They asked for the mistrial. They asked that she declare it, whereas the state was saying, no, keep them. I want them to continue to deliberate back there. Defense is like, no, you gave the charge. They're done. And she agreed with the note. She was done. So like the only thing that stops that, which I think is preposterous, frankly. I know that there's plenty of people out there that think that Canoni was biased. I thought that she handled the trial like a champion. To be frank, I thought that the defense got everything that they wanted to get in short of being able to say that there was an FBI investigation. They were able to get in the results of that investigation, everything that they wanted. It all came in. I was hard pressed to see them not getting anything in that they wanted to get in during that trial. That's what tells you whether or not a trial was equal in terms of what they were allowing in. And I thought the judge, I thought she ran a very smooth trial, to be honest with you. And I get that there's people that don't like that, but that's an honest opinion. It just is. And that's from somebody who's tried cases for an awfully long time and who's had judges where I'm like, man, this judge just hates us and like rules against us on everything. We're being denied getting anything in, and she's cutting us off at the legs. I just felt like they got a lot of the stuff in. However, when she makes this ruling, which I'm anticipating that she's going to, is that it's been waived. She doesn't have to address it. Unfortunately, they're not going to get to the issues. You guys can bring it up to the appellate court on an interlocutory appeal to see if they agree with you. But where I'm at right here, it's done. Like I'm not going to get into it. In the longer, the more remote in time it gets, the further away from those deliberations we get, the tougher it gets to bring those jurors back in that room and say, okay, well, I'm going to put you in some kind of a time machine, and I'm going to put you back mentally to now before the time that you've like dug into everything that's been out there for the last year and a half about this case. Cause I know that you have, if you're being honest, and I don't know how that's affected your mentality or your decision-making at this point, but I'm going to try to get you to go back to that moment in time and be as honest as you possibly can. Did you, in fact, all unanimously agree on counts 1 and 3? You know, it's like how, if you're the Commonwealth, you're arguing, well, like if they didn't write it, how do we know?
Right.
Like, you know what I mean? Like,
what do you mean by agree? If you just mean, did we say, well, let's go ahead and consider this other one because I think we all feel more strongly about that.
right.
I don't think they realized the legal function of not considering the murder, of moving on from the murder is an acquittal, meaning she won't get retried on that. I don't think they understood any of that because of the way that the that verdict slip was written. But I fully agree with you, that Bob, that judges look for the easy opportunity to avoid a mess. And this is an absolute mess. And she's given a wonderful opportunity here to say, you didn't lodge timely objections. And if you got a problem with my ruling right now, go ahead and take it up with a higher court and let them suss this all out. Yeah,
exactly.
Right.
And if they're going to kick it back and say, all right, look, this is what we're going to do, you know, because and that's a very sticky issue for the appellate court. Like
Sure.
I don't know that there's much language out there that goes directly on point to this issue. I mean, there's some cases that we've seen that are, you know, they're not on point, but they've got situations where jurors were, you know, that they had unanimous agreements as to certain counts, and you know, but there's nothing directly on point with this situation. And then you've just got so many other external factors at play with this case in particular, where you've got the jurors asking, you know, that they extend, you know, the prohibition against releasing their names and, you know, naming the bloggers and all the shit that's going on out in the world surrounding this case that we can't pretend don't exist as having a factor on this case, because they do. You know, I mean, she made rulings about certain people being in the courtroom when certain people were testifying. You know, I mean, like it was like there was this invasion of kind of social media into this case in a way that I've never seen, you know, where it actually reared its head within the trial itself.
Yeah.
And all of these things are factors. And like Canoni is just going to be of the mindset, like you said, like we're saying, she is not going to deal with it because she doesn't need to, because the defense failed to do their job. I mean, like I thought that Yannetti and Jackson did a fabulous job during that trial. Like I really did. But objectively looking at what happened at the end, they missed it. They missed it.
Oh.
And unfortunately in the law, as Josh, you'll attest, as Allie will attest, there is no wiggle room. When you have deadlines, when you have things that must be done in order to have that issue preserved, whether it be, I've got to file my notice of appeal within 30 days. You file it on 31 days. I'm sorry, you're done. That's it. It's over. You know, like, I mean, the deadlines in the case are so hard and fast. There is no wiggle room. And if you don't preserve an issue for appeal, you know, it just doesn't. And beyond that, I mean, you have to re-up on issues. Like you can make an objection early on, but then you have to preserve it again at trial. Like say, for instance, something happened at pretrial you've got to re-up on that objection at trial. Otherwise, the appellate courts will most likely leave it to be waived.
Well, and to your point, something that may have been missed is I do think that part of the problem that created this whole mess with the jurors to begin with was that verdict form, that verdict slip, that there was not a way for them in a clear enough way to explain being caught in this exact position where it's like, listen, we're not acquitting her of everything. We're not saying not guilty of everything. We're just saying not guilty of one thing, and then we've moved on to something else. If that's in fact the consensus agreement they had all come to, and there wasn't a way to indicate that on the form. But to your point, Bob, Jackson made that objection initially, said, I've got a problem with this verdict form. This verdict form is not clear. But then they provided the remedy and the judge accepted that remedy. And an appellate court is going to look back at that and go, hey, you sleep in the bed that you made. And so you offered this remedy. The judge accepted that remedy. You cannot now try to take advantage of errors that may have been created by providing your own remedy. That's, I think, going to be a problem for them, even if they get to appeal on this.
100%. Agreed. And that was their language, or I mean, some form of her, she capitulated to the extent where because at first she was adamant. She's like, I'm not changing shit.
Right.
Get out of my face.
May have worked out better for them in this situation.
100%.
But then they offered that language and she said, okay, I'll go ahead and put that language in there.
Right.
And ended their opportunity to appeal this.
Yeah. And I'm seeing like great comments in here where I hear you guys, like all of us lawyers in this room hear you, especially we are like Josh has been on both sides of it. He's prosecuted, he's defended cases. Allie and I are like full-time only defense attorneys. Like we understand what you're saying. It does not seem equitable. It does not seem as if justice is being served. If in fact those jurors came back 12-0 on those 2 counts in the state or the Commonwealth has the opportunity to try them again, it certainly has all the earmarks of double jeopardy, but the problem is, like I keep saying, there are hard and fast rules in court. There are hard and fast rules in terms of preserving issues for appeal, and they simply didn't do it. And whether or not the appellate court is going to say, okay, well, ultimately, even though we can't find anything on point, we find that this at least deserves an evidentiary hearing where we're going to require the judge to bring in all 12 jurors to inquire from them. Probably, I would suggest without counsel being present, that she does it on her own accord, brings those jurors back in where they're not having anybody in that courtroom, almost where they're doing it back in chambers. And she just has discussions with them, where they say, look, in the interest of justice, we've got to weigh the constitutional rights of the defendant as having more weight than whatever may be in resistance of that, because we honor those rights so much, that they're going to always have a little more weight than everything that is fighting against it on the other side of the scale. And, I could see that being a situation where the appellate court says, all right, but then again, you always have to think about that slippery slope in terms of precedent, like that is what the mindset of an appellate court is always thinking about. Now this law is precedent and it is going to be applied in other cases. And what kind of slippery slope does this create where you're giving, courts and judges and lawyers the opportunity to haul jurors who've been discharged from a case back into the courtroom just to make sure that they understood what they were doing, or they didn't. Like, I just like, it's a very, very, very long and dangerous bridge that they're asking them to cross. And I don't know if they'll be willing to do it. I just don't.
Yeah.
Like, it should have happened then.
I do not. I mean, I applaud the defense for making the motion and for going for it and for giving it a try.
100%.
But I agree with you. We all have experience with how these things actually work themselves out. And it is very rare to see the courts or the appellate courts do something as extreme as essentially resurrecting an acquittal where a mistrial has been declared. I mean, it's just, they're just, like you said, the precedent that would set would be, have too many ramifications beyond just this one trial that they're just not going to do it.
Yeah, no question. Yeah, not a chance there, Aaron. Very, very different scenarios. The procedural posture of the Richard Allen case was very, very different than this one in a lot of different ways. And that's what I've always tried to, really kind of shine the light on with respect to Richard Allen's cases. People like to misconstrue me talking about innocence or guilt, and that's just not what I've been doing in that case because I don't know what the evidence is. I'm just telling you what the law is, Aaron. Like, and people may not want to hear it, but I just call it like I see it always. And I think that's the same can be said for Josh and Allison. I don't have a stake in the game here. I don't have a dog in the hunt. I don't have a horse in the race. I'm just calling it like I see it. And I'm telling you, prepare yourselves because this thing is, you're not going to get that hearing that you're all wanting, at least not from Judge Cannoni. If you're going to get it, it's going to be from the appellate level is my prediction. It's not what I think should happen. It's what I think is going to happen. There are two different things. So, but like Josh, like when we get the, later after the filing, after the motion to dismiss, and then we get the affidavits from Jackson and Yannetti, and then we get a couple more affidavits from Jackson talking about these jurors just keep coming forward. We're all saying it's 12-0, but then we get this affidavit where it's one of the jurors is saying, look, we want our names withheld still. We want that extended because of all these different reasons. That juror has certainly heard about what's going on here with this issue, and yet there's no mention of it in an affidavit that was prepared by that juror's attorney. So, to me, that's befuddling. To me, that flies in the face of common sense in that this is factual, that all 12, why wouldn't that juror say, oh, and by the way, just to confirm, I'm going to throw my hat in the ring. Just to confirm,
very good point.
No mention of it. It's like there's something that's off with it. So I don't know.
And the other ones who haven't come forward, isn't their silence kind of saying something too? If they are now realizing that a great injustice has taken place because they weren't able to explain that they were acquitting her of the murder charge, and they realize now, perhaps they didn't appreciate it at the time, but they realize now the great effect that could have had on this case moving forward. Why aren't the other ones coming forward? Or do they not entirely agree, or do they just want no part of this anymore? And will them wanting no part of it present problems to actually have a full-fledged hearing on this?
Yeah. I mean, it's like, I just can't figure out what that full-fledged hearing looks like.
Yeah. Yeah.
What are you doing? How are you able to, because there's nothing in writing that we know. The one thing that I do not believe is that they marked counts 1 and 3 as not guilty and that Judge Cannoni had ignored them. Yeah. That didn't happen. I think she got back 3 blank verdict slips, and that's what she had. I don't think that there's anything in the note that she kept out. Those are made of record. It'll be in the appellate record. All jury questions are made a part of the record. So there's none of that happened. That's all crazy conspiracy shit that just did not happen here. Cannoni would never do that. There's no way she's blowing her career up just to see Karen Reed get convicted. That's no one's convincing me of that. That's nonsense. So I think what we have is a situation where it's uncharted territory. We've got this just bizarro world situation where I just don't, the thing that I don't get is why didn't the jurors write that in the note? If all right, look, we're a little confused. We're writing to you that we're deadlocked on, we use the word charges, which certainly could be argued that they're talking about the lesser included in count 2, right? Or it could mean all of them. but like, why, when you have somebody who's writing such just concise,
Thorough
thorough,
note too.
well
Yeah.
thought out notes, like, why wouldn't they ask, all right, well, so we have one question. Here's a
Yeah.
question for you, Judge. We have gone unanimous on counts 1 and 3. Are we allowed to fill out that form? And she would say, of course, yes, thank you. So it's a partial mistrial. It's a, mistrial is to count 2, but we've got verdicts on 1 and 3. You know what I mean? So it's just like, I don't know, man. Like, something about it is just like, and like you said, like, I forget if it was the second juror that talked to Jackson, said that they all were on a text thread together. So they're talking about it, like, collectively. I don't know if all 12 of them are on there. I would imagine so. Like, I think you kind of, especially because it sounds like they were able to really respect one another in terms of saying, look, this is how I feel about this case. And like, all the arguing in the world is never going to change that. And then you had 12 jurors that decided, look, we're going to agree to disagree, which is phenomenal. I love when people just are able to hold their stance in the face of other people coming at them and saying, no, you're wrong, you're wrong, you're wrong. They plead their case and they say, you still haven't convinced me. That's not where I'm at. So I respect that. That the jurors held firm no matter which side they're on. I mean, that's what you want from your jurors. You don't want jurors caving. That's why I hate Allen charges or dynamite charges. I feel like it puts undue pressure and coercive type pressure on jurors to make a decision, which flies in the face of what the process is. So I've never been a fan of it. I mean, all of us want a verdict, especially the lawyers that are trying the cases. None of us want to retry cases. None of us. I mean, it's like, that's a nightmare scenario.
It's
But
exhausting.
oh my God, man, it's unbelievable. So yeah, I don't know, man.
Well, and I'll tell you the reason, like, that I keep thinking, harkening back to them trying to argue a double jeopardy ground or a due process ground on the basis of, like, police and prosecutorial misconduct during trial, is because these things happened and they never requested a mistrial. And I think that's because the defense didn't want to win that way. They wanted to, get her. She's factually innocent. So this is sort of a way to kind of backdoor those issues and get them before an appellate court, because otherwise they might be deemed waived. I mean, they didn't object at trial.
Wait, to what?
So my whole thing is, like, they could argue, well, here's another reason why we should consider this to be double jeopardy. Look at what they did during trial, and they did that to, like, intentionally taint the jury or in hoping to sort of get a mistrial, because that's some of the things that they talk about a lot. It's like, well, prosecutorial misconduct's not an issue unless it was, designed to have the jury, designed to get you to declare a mistrial. But you could make this argument that they did this because they knew they were going to lose, and it was in hopes of either getting a guilty verdict or hoping the jury would come back hung. Like, something that brings the misconduct during trial into issue, since they didn't request a mistrial during the trial. I mean, and especially because they're about to be able to appeal right now, so they could sort of roll this into a double jeopardy argument, slash due process argument, to bar retrial on any of it or on those counts, like, whatever you want to do. Because in Massachusetts, they say after there's a mistrial, you have this right to have a sufficiency of the evidence hearing, to determine whether they should be allowed to retry you on those issues. So if they bring up these other issues in here, instead of just relying on a strict, because they all sort of attach to double jeopardy argument, but they're relying on a strict, they had a verdict, that verdict counts, you should put that verdict into effect. And these other issues would allow them to give other reasons why, other than that just straightforward, strict, they had a verdict, ways to get the court to consider either, other grounds for finding double jeopardy, and then allows them the opportunity to present the misconduct during trial and any other issue to an appellate court before they go into that second trial.
Yeah, I mean,
is that making sense what I'm
yeah,
saying?
it does make sense. And to that point,
Josh's face is like,
well, I didn't no, I didn't realize you're saying that in Massachusetts they have an actual hearing on the strength of the prosecution's case to even allow the prosecution to bring a retrial under normal circumstances.
under their common law double jeopardy principles, what I read says that, and I'll read it again here. Under Massachusetts law, where a mistrial is declared because of a hung jury, after the defendant moved for a finding of not guilty, which they did, common law double jeopardy principles entitle defendant to review of legal sufficiency of the evidence before another trial takes place, during which the court must decide whether rational trier of fact could have found each essential element of the crime charged beyond a reasonable doubt at the first trial. If not, retrial of the defendant would violate common law principles of double jeopardy. And that's where they went on to say at that hearing, the evidence will not be sufficient to withstand defense's motion for this sufficiency hearing, unless it allows the court to do more than find that there was some record evidence, however slight, to support each element of the offense. Further, evidence is insufficient if it merely piles inference upon inference, but the most important one, if it tends equally to support either of two inconsistent propositions, i.e., she hit him, i.e., there was some other thing. And clearly they're even just getting to their unable to reach a verdict part shows that there are equally two inconsistent propositions here. And that's how you say, all right, clearly they wouldn't have that rule if the judge's determination at the directed finding verdict was sufficient, right? Like, because they say, well, you already decided that issue. There's something about the fact, and I think it's that argument that I've been making, that they can kind of rely on the fact that 12 jurors couldn't agree. So there are equally two, two different propositions. And then you have this compound fact that jurors are saying we actually did agree on 1 and 3, or we softly agreed. Even that would be relevant to this insufficiency of the evidence argument, even though I don't think that would be a grounds in and of itself to bring the jury in to ask these questions. You know what I mean? But I think it's a way to piggyback that.
If Cannoni wants to do it, right? Like, this sounds like she's got the authority to do it without even getting into this whole, essentially finding that they did acquit her. The judge could say, well, I'm going to acquit her based upon what you're just reading to us, in part based upon the evidence that came out in trial, and now me learning that they had in fact been maybe had found that way. But to Bob's point, if Cannoni wants to do it, I don't think she wants to do it.
No,
I don't think I don't even think it's a bias thing. I think it's just, I'm not getting into that. That is so dirty, and I'm just going to let you guys have another try at this whole thing.
Yeah, it's like, dude, Boston cop lost his life. Like, I'm not going to be the one, it's
not going to come down to me making that decision. Yeah.
The other big thing on this is, and she mentioned it in the hearing about the appeal, the law does allow them to appeal that denial of the insufficiency of the evidence argument. That's why I'm saying I feel like they need to roll it in right now, because they're going to, want to appeal this. And I like literally had this tweet ready to go on the day of the assassination attempt. And then I was just like, I'm not going to tweet about everyday common, nonsense. But, like, I'd hate to see them, what they're going to appeal that and then try to come back and make this other argument and then appeal that. I mean,
well, I've got questions that are twofold for you, Allie. So one, you and I both noted when they made their motion for directed finding at the close of the state's evidence, instead of articulating and making it to each count individually, they did it as a collective. Like they just made one motion for directed, instead of saying we want a directed finding as to count one because we don't believe that they were met the their burden in terms of the element of intent. Instead, they just made it like regarding all of them, which I
Right,
thought
but
was a mistake.
I still think even though they could have more eloquently argued individual grounds, they still made them to each of them their individual counts. So
I
it's
didn't
not like
I didn't
it's
get
not
that sense.
yeah,
Like
but what I'm saying is legally, that's by asking for a directed verdict on all counts, it means any or all counts.
yeah, I understand that, but in a case like this,
Like
like
they should have made those
and on
strong
top of that,
arguments.
they didn't do it at the end of trial, at least that we
Oh,
didn't
I
hear.
when you weren't on, I checked the docket and they did I did
Oh,
see
okay.
it on the docket that it was denied.
Okay, good. Thank you for that, because I was wondering. And then so the final question I have is like, what are the grounds? Are these even grounds that you can bring up in interlocutory appeal?
The one I know for certain is the grounds of this insufficiency of the evidence hearing, that if it's denied, then you can appeal right away your motion for directed denial of your motion for directed verdict and denial of that. So that's why I'm saying, and clearly the judge is saying that they are able to appeal this part as well, because she said that there, and I did the research to see that they have this like one panel Supreme Court that you go to if you're denied this insufficiency, um, denied at the insufficiency of the evidence hearing, which allows them to also appeal the denial of the directed verdict.
I'm just saying with that catch-all of using one particular argument to cover all of the counts in a situation where you clearly have one of the counts that was not proven. To just kind of not like pull that one out on its own, just to kind of argue that on its own merits instead of like, I don't know. Like, I mean, I get what you're saying, but like we certainly, I would like to think that we would have argued that specifically, that count one.
Oh,
They simply,
absolutely. I think right. I think that they should have made their strongest arguments. All I'm saying is by them saying we're asking for a directed verdict on all these counts, blah blah blah. It's not saying it's not like they waived it for just one count. It that is as to each count. Although I think better practice would have been to actually outline your strongest arguments as to each individual count. I still think it was to each individual count. And I really
let me ask Josh. So CH, one of our mods, had asked, can the Commonwealth change the charges for the second trial? As a former prosecutor, Josh, why don't you tell us what your mindset would be? Like, so let's pretend you're Lally, except
Yeah.
much more handsome. So, but like this is your case, and you're going in. You
No,
got to
a
you got to
little bit
try.
more lively. I've said this before. I think he should take a cue from this first trial as if it were a mock trial, and realizing how this test jury came out on this thing, and that he doesn't have a case for second-degree murder, and
Right.
just proceed. He can, to answer the question, they can drop charges, but they can't start adding charges or adding new charges, but they can go ahead and drop. They right now, the Commonwealth could just drop the second-degree murder and solve all of these issues and problems and say,
Yep.
we're just proceeding on the lesser included. It's
Yep.
they have a stronger case. They've been told that by this test jury now. And, I think it cleans up their case. I think it solves a lot of issues and problems for them.
Yeah.
And they just proceed on that. It's
And look, man, I mean, like we don't know, like, and it's not just this test jury, which is 100%, but like, these guys are watching talking heads on TV, YouTube.
Yeah.
Like Lally's watching this shit. Like every lawyer that I've heard talk about it, doesn't matter which side you're on. I haven't heard one lawyer, not one, even the pro Karen Reed is guilty. I've not heard one lawyer, and maybe I'm just missing them, where they've said, yeah, they got her on the second-degree murder. As all the evidence came out at trial, people that were dead set on, yeah, she killed him intentionally, had retracted and backed off from that, just in terms of the evidence that was presented. And that's what I'm always saying. We always have to wait to trial. Like, it doesn't matter what people are yapping about prior to trial, because we don't know what the evidence is. It's got to get into trial and it's got to get vetted. And then we come to a conclusion. So, like, with that being said, I agree completely. I think that the second-degree murder charge plays against them. I think it works against the Commonwealth because it gives a conflicting feeling to the jury. The jury saying, okay, well, they're saying that she did it purposefully, but if she didn't,
Right.
you can rest your laurels on the manslaughter with OUI. Like it's like, it's not giving the jurors the feeling of confidence that, like, this is the one, because it's not a lesser included. It's a standalone charge, completely separate, where it's really a different argument altogether. You know, one is one where you're arguing she did it intentionally. She was pissed. She wasn't going to let him get away with, like, dumping her. She ran him down and killed him intentionally. When the manslaughter OUI ain't that.
Right.
You know?
No, there's a strength to being able to stand up at the end of trial and say, folks, we're not even asking you to find that she did this on purpose. We're just asking you to find X, Y, and Z. There's a strength to that. There's a power in that concession that they weren't able to take advantage of in the first time around, that I think they could this time around if they were smart enough to dismiss that. Clean up your case. Clean up the case is too big, too unwieldy, too broad, and you can do a lot to clean it up if you want to bring these charges again by just dismissing that count.
Yeah, no question. And like, the other part of this that we don't know is that you've got, like, Lally's not making the call here. Let's just be clear about that. Morrissey's making the call here. His boss is making the call here on what's going to happen. And we do not know what type of pressure Morrissey is having applied to him in terms of what he's hearing from his superiors, people that he answers to. You know, like the one thing that I think that you could speak on is that, look, prosecutors rely on their cops. They are their eyes and their ears, and they are their evidence collectors, and they're integral in terms of what prosecutors need to get done. They protect their cops. They do, whether it be a trial, but, like, that is a very real relationship that people cannot underestimate, how far prosecutors will go to protect their cops. And, you know, when you have a situation where you have a dead Boston cop, like, I don't know what kind of heat they are under, especially with all the bullshit that's gone on around this case from the outside, you know, where they could be going to Morrissey saying, dude, I don't give a shit. There's no way you're dropping that second-degree murder. We're not walking this thing back. Make your case better. You know what I'm saying? It's like, we don't know what's going on from the pressure and the political side of it.
They should almost hope there's a special prosecutor brought in. They should be begging for one. I mean,
if I was Lally, I'd be like, you know,
I no objection if the state.
I'm good. I feel like once was enough. You know, yeah, I don't know. It's fascinating though. Like, legally, it is. If you're a law nerd, like, this whole thing has just been a fascinating case. It's like, it's weird to think about just kind of a simple run of the mill potential manslaughter with DUI or OUI turning into this thing, man. It's like, it's a whole thing, man. You know, that just, it's interesting. It's been a really, really interesting case. And I get why Jay wanted to dip out, you know, I mean, like, trying to deal with this shit. And I'm going through the same thing with Delphi, you know, I truly am objective. You can see, I'll come after defense attorneys if I feel that they've failed in a certain aspect. And it's not me being overly critical. It's me being just observant as to something that should have been done that wasn't, period. You know, like, and believe me, I've made plenty of errors while trying cases. No one tries a perfect case. That is not how the law works. We are not robots. We are all humans, and there are always going to be mistakes made in trial.
Always.
You know, what you try to do is avoid ones that are catastrophic. You know, the catastrophic errors are where you're like, oh my God, because once your client is in the system, like getting that undone is Herculean. It's like it's near impossible. People just like that. Anybody that follows the judicial system knows that once your client is convicted, trying to undo that is literally moving mountains, and it's so difficult to do. You know, so you never want to get to that point. That's why I always scoff and jest when they're like, well, you know, they could take it up on appeal. I'm like, oh, yeah, that's a real remedy.
Right.
I'm like, sure, you know, so yeah, it's
6 years later.
yeah, we're 25 years later, it's you know, it's crazy. But so what do you got going on, man? What's happening with you? What's popping? What's going over at Courtroom Confidential? What's happening?
Courtroom Confidential. You know, I got a video coming out tomorrow on Corey Richins. I don't know if you guys have been following that one. So I did a real deep dive into that one, and then always have the Friday episode where try to cover everything from the week, and it's becoming more and more difficult because there just seems to be so much going on. But you know, I'm trying to dive more and more into this world as much as I can, and I'm going to try to get into doing some live reactions more and following trials live. It's fun, it's exhausting, and I have that troubling problem of I'm actually still a practicing attorney, and I just got to figure out what to do about that, and then you'll see me on here full time.
Yeah,
Hey,
man, dude. I know, obviously I know. And that one, the good looking one up in the upper left-hand corner up there, she knows. I mean, 'cause she's too, man. So it's like, ugh, like we're trying to get her out. We're trying to get her out. Like I'm trying to get you out, Josh. I'm trying to get everybody, all my friends, I want out of practice so we can all be happy. I just want all my friends to be happy because it's really, really hard to be happy when you're an attorney because it's just a gut punching type of profession that, like I rarely talk to attorneys that are like, I love it. I love every bit of it. Like I know a couple of guys that just love every second of it. But yeah, that Corey Richins, man, you beat me to the punch. I've got so much research on her. Like we're going to have to do, we'll do some joint stuff on her. I've got lots and lots of good stuff. I have a friend of the show has just been feeding me massive amounts of Corey Richins stuff. And like people are, everyone who likes to think, oh, Bob thinks everybody's innocent. Well, I don't think Corey Richins is innocent. I'll tell you that. I think she's in deep, deep shit. And it's man, that case is unreal.
Yeah.
Unreal.
Yeah.
So yeah, that's cool. When's that airing? When's that video
tomorrow?
Coming out?
Yeah, it's going to be released tomorrow morning. So, I did a lot of research on it. It's funny though; these cases are constantly evolving, and I could have spent 2 hours talking about this thing. I didn't spend nearly that much time, but there's so much going on in it, and it's funny because it's one of the, and that's what makes an interesting case to follow. Is it's one of those things where, I go into it and at some points I'm like, boy, she is cooked. And then you start to hear some of the defense arguments and you start to realize, okay, this is not as clear cut as I once thought. The entire prosecution case, not the whole thing, but a lot of the prosecution's case comes down to this housekeeper informant who is the one that was helping them piece together how she was purchasing drugs and everything else. And if a prosecution case is going to come down to one witness who happens to be a person that might be criminally implicated themselves, who's also got a criminal history, that's not as strong a case as you might think. So it's definitely an interesting one to dig into. And I think that
make no bones about it, it's circumstantial. It is highly but. Yeah, so Emily had asked, is this the one that poisoned her husband allegedly and literally bought $1 million house the next day? Oh, and then wrote a book.
Right.
Well,
right.
Yeah, that's the one. Yeah,
that's the one. Yeah.
and not only wrote a book, but it's a children's book on how to guide your children through the loss of a parent.
Right.
Oh,
it's a book about his death. It's a book about grieving his death. Yeah,
exactly. So yeah, it's it's a crazy one. It's a crazy one. Were you able to get into the walk the dog letter? Did you get into that?
Got into that whole thing. Again, it amazes me these people who the true kind of diabolical sociopaths. I'm not saying that's what she is. I'm trying to be objective, but there is a personality type that cannot help themselves when they're behind bars of wanting to continue to kind of control the narrative and control the way the case turns out. Another one I'd been looking into is James Craig. He's the dentist who very similar poisoned his wife. And he recently was now indicted on further charges of trying to get a cellmate of his to plant some evidence. I mean, it's just amazing. These people, they find themselves behind bars. That doesn't mean that they all of a sudden turn into a different person.
No,
they are still trying to complete the crime, even though they're behind bars.
Yeah, they're doubling down, man. They're doubling down. Yeah, it's all right. So everybody, make sure you're subbing over at Courtroom Confidential. We've got the links right here.
Thank you, guys.
And make sure, because Corey Richards, we're telling you, Josh and I are telling you right now, that's going to be a banger trial. That's going to definitely be a banger trial. I have a sneaking suspicion, Josh, we will be hanging out a lot during that trial. You, me, and Jay will be
for sure.
Definitely covering that together. Yeah. So what else going on? Anything cool? Anything else good, man?
No, I twisted the hell out of my ankle getting off of a jungle gym playing with my 3-year-old the other day. So I'm walking around in a walking boot and have to go see an ortho. So that's loads of fun. If you ever want to feel really old, go play with your toddler at a jungle gym and then end up at the ER later that day.
Oh yeah, no shit. You probably just made that it was probably like a 6-inch leap off of the jungle gym. You're like, oh my God. Yeah. No, been there, dude. Been there. Yeah. It's I'm sorry. I'm sorry that you're going through that.
I'm good. At least another reason why I need to do this more often is because now I can just sit.
Yeah, exactly. And I can attest, Josh is very fit. This is not a matter of Josh.
Thank you for that.
Josh is a fit dude, man. So this was just, oldness. We're old. Yeah. It's like you're just not as sure on your feet as you used to be. It's kind of like, when I'm skiing, like I just don't have the confidence, because your center of gravity seems way higher the older you get. And I'm talking about like snow skiing. It's like I get really, really, really nervous now, where I never used to feel that way, but now it's just one of those things. Oh yeah, Travis says loves the Friday recaps on Courtroom Confidential.
Oh, thank you, Travis.
So tell us a bit about that. Is that where you're kind of giving a run through of all the trials that are?
Because we wanted to do something. I had the podcast that I've been doing with True Crime News for so long, and I wanted to do something that was similar in that it was kind of a way to check in on cases and the developments that happened through the week, instead of trying to stay on top of every individual case. Just kind of give a rundown and recap of the week. And what's great about it too is it lends itself to be a podcast. So we also have a podcast on Apple Podcasts and Spotify and all the other ones. So we're keeping that as kind of our main show, but then we've been adding more and more content on the channel through the week, like this Corey Richards episode coming out tomorrow. I just did a dual live with Jay earlier today on the Adelson thing that we were talking about. So I'm just, as much as I can carve out the time, pushing more onto the channel, but that Friday episode is kind of our mainstay.
I love that. And that's cool. Like that's kind of the concept. And we're going to start doing the morning drop, which is going to be a show Allie and I do.
I'm going to let you guys take over, because I got some work to do.
Oh, you're dipping?
Love you all. Yeah, I got to do it.
I mean, you were so talkative the last 20 minutes. We're going to really miss you.
I actually was getting out a post directing people to here for with Josh, but then stuck in all that stuff that I never posted after the the assassination attempt. So
yeah, no, and I was totally giving you shit. I appreciate you carrying the load this morning while I was on Law and Crime. So I love you. You're the best. I'll see you.
I actually hated it.
Well,
like from the literal second it turned on, and I was like,
let Allie talk. Like, I'm kind of like the one who guides her through. Like
No, it's
like,
just for some reason I'm more able to talk like when there's someone else here. Like it comes on and it's just me and I'm like, hi.
it's weird. It
Yeah,
is.
it's weird.
It's a strange phenomenon when you're alone. Like it's definitely
It's
you've
like
got to get used
from
to
the
it.
second that it comes on, I was just like,
Hello,
oops.
hello. All right,
And then
babe.
I wanted to do that thing where I was like, maybe Bob's gonna be coming soon, guys. So I was like, all right, let's just get right to reading
I'm
the
sure you
motion.
were great. I have no doubt you were great. All
All
right, I
right.
love you. I'll see you downstairs.
Let's see.
So Sarah Brown, $5 holla. How can we get mandated nationwide that each juror needs to turn in a verdict form regardless of the verdict? This happens more than we know for sure. It's an interesting concept. You got any thoughts on that?
Well, it does happen. I mean, usually the way this is supposed to work is they bring them into the courtroom and they poll everybody after a verdict, though, is the problem. But that does happen, Sarah, in that, oftentimes a verdict, guilty, not guilty, they will ask to have the jury polled. And so you go through all 12 and have them make sure that this is in fact the verdict that they've agreed to. Problem here is it wasn't they weren't polled because they were hung and the judge never decided to inquire, it was funny to me because usually that is another step that you'll see judges take where they don't ask, which way are you leaning, but they'll ask at least give us an idea of what the split is so they know how dramatically they're hung and if there's any value in even having them go back into the courtroom. If they're hung 6-6, usually everybody's like, okay, we're not, this is deadlocked. But if it's 11 to 1 or 10 to 2 or something, they might.
See, but that's the problem is that like the lawyers nor the judge can like flat out ask. They have to like
Right.
volunteer what the split is. You know what I'm saying? And it's like, because that would be super helpful.
Yeah.
But they consider it to be coercive if you're asking, like
Yeah.
it's like so, but like we've had it many, many times where we've had hungs and they come back and the judge does an Allen charge, which is what we call it here still. And but they'll give the count. But we've had judges tell us as the attorneys, I'm not telling you what the count is. Because they would just want us to they want us to make our argument as to whether or not we want them to give the charge or whether or not we're asking for the mistrial. Because that's a calculated risk when you don't know what the count is. Because I like say, for instance, the defense was running to say, okay, well, we want you to declare the mistrial. What happens if they're 11-1 NG on all three counts?
Right.
That's a calculated risk where you're like, had you known that information, you're probably saying, go back in there, convince that person. There's got to be one piece of evidence that can tip the scales. You know what I'm saying? So when you don't know what the count is, it's a whole different ball of wax, no question about it. But yeah, and I had explained polling the jury isn't what I think people think that it is. And Josh just went into it. It's basically just asking a jury. And once they come to a verdict, like you do not poll jurors that have not reached a verdict. There's nothing to poll because all you're polling is this your actual verdict? Is this your individual verdict? And they ask each juror one by one just to make sure that every juror has the right to say, yes, this is how I voted. No one forced me into it. This is how I wanted to vote. And this is what I did. And that's it. That's what polling the jury is. It's no, they're not getting into the details of the deliberations or any of that stuff or what it turned on or what the count was initially. They don't get into any of that stuff. It's real quick. Just, is this your true and correct verdict? Yes. Is this your true and correct verdict? Yes. One by one through the jurors, just so it's on record. So
yeah. I really think the fallout from this thing, if anything else, is going to be those verdict slips in Massachusetts. I think if I were a practicing attorney in Massachusetts, and it sounds like that is what the verdict forms look like, I might be bringing this up again because this to me, I can't imagine how this hasn't caused trouble in the past. That because end of the day, the jurors may have made the mistake, if you want to even call it that, of not letting the judge know they were hung, but they filled out the form correctly because there was nowhere for them to indicate this scenario.
Right. Exactly. You know, and like, I think where it gets confusing is not in the slip, the verdict slip or the verdict form. It's in the instructions.
Yeah.
Like that's what people keep forgetting, because everyone's eyes gloss over when the judge is always reading the instructions to the jury at the end. You're like, Jay finds it boring as shit. And it is. Like, if you're
Yeah.
just sitting there observing a trial, listening to a judge read these things, when you're not really kind of like in tune with how important every single word and instruction is, like when you see those jury instruction conferences, that shows you just exactly what we do for a living. We are parsing each and every word contained within a sentence, because words matter. You know, like
Right.
one word can swing the way something is construed, and it happens all the time. So, you know, when she was reading through the instructions on how to deal with the verdict slip for count 2, I'm like, this thing is a cluster F. Like,
Yeah.
this thing is a nightmare. You know, I'm like, this is going to be very difficult for this jury. Like, forget about the slip itself. Like the I mean, just the directions to how to work your way through it were so convoluted and so difficult. I'm like, they're going to have a really tough time, because 1 and 3 were simple. It's like guilty, not guilty, boop, boop, you
Right.
know, and it's like, there just wasn't as much language where it's an acquittal first state or it's not,
Yeah.
they're not. So you don't have to acquit on that one to get to, they're all standalone charges. You know what I mean? And it's like, if it's true that they were 12-0 not guilty on all of them, they clearly did not understand that that was the concept, that you did not have to fight, like you didn't have to find not guilty on 1 to get to 2 and down the road, but you did on count 2. Like that
Yeah.
in and of itself, you know what I'm saying? So I could see a world in which it was confusing, but I can also not see a world in which that foreperson who wrote that note or those notes didn't think to ask.
Well,
know?
and that's why I think you saw the judge and everybody else, quite frankly, not really want further inquiry. Like there wasn't anybody going, hey, we really need to inquire of them if they're at all hung on everything or just on one count, or if they've come to a decision. You know, there wasn't even a question of doing that because of how that note came out so thorough. The note is one of the clearest notes I've ever seen of a jury indicating that they're hung. Usually, I'm sure you're used to this. The notes I'm used to are, hey, we don't know what to do. We can't really agree. Should we do anything? You know, I mean, they're very kind of vague and almost, you know, even when they are hung, it's rare for them to be so emphatic about, we've done everything we can. We've looked at everything. This is just a pure deadlock on opinion, and we don't know what else to do.
Right. We're not confused on the evidence. We're all clear on that. This is just a fundamental difference on what we think happened here. And frankly, I agree with you. You know, the easiest way for the Commonwealth to moot all this is just drop the first count. It makes all this shit go away immediately. Like all of it go away. Like if they say we're not moving on the second degree, this all vanishes, because there is no argument as to the manslaughter charges. So that then they just go to trial on that, and then they have a real clean trial. You know, and it's going to be a different trial. It's not going to be a replay.
And it's a smart move too, because you're, you know, say what they will about the arguments on whether or not the statements made by these jurors should be believed. I think they believe that those statements are being made by the jurors. I think they're arguing against it, but you're being told that you couldn't convince 12 people, that you had this, you put on this total elaborate trial, called every witness you wanted to call, and the best you could do, you now have 12 people who say that they were not going to convict her of that second degree murder. Why not learn from that and say, okay, well, let's not let ego get involved here and realize we don't have a strong case when it comes to second degree, but we might have a stronger case when it comes to the lesser included, and just go with that.
100%, man. 100%. To me, it seems like a no-brainer.
Yeah.
You know what I'm saying? Like, I just
Right.
don't like
Politics might be playing a role in this whole thing.
Yeah, I don't know, man. It's one of those things where it's like I was saying, I don't know what kind of pressure is being applied externally, but I mean, I'm sure there is some. And again, it's like when you're dealing with cops and a cop's death, there's going to be pressure that's going to be applied, and it's just one of those things where you're like, man, hopefully they'll do the right thing here, because ultimately, when you sit there and you look at, John O'Keefe's family, in particular, his mother, to have her sit through it again,
Brutal.
just do it right by her,
Yeah.
like go with what you think is your strongest case instead of trying to hit some kind of crazy home run where you don't have the evidence for it. You know
Yeah.
what I'm saying? I mean, like the punishment, the potential punishment on a manslaughter is pretty heavy duty. I
Yeah.
mean, it's 20 years, man. So, I think that you've just got to kind of look at that and take into consideration, the people that you're trying to get the justice for and how it's affecting them ultimately. But, whether or not prosecutors do that, I think is probably a prosecutor by prosecutor evaluation, in terms of whether or not that how much weight that gives it. But so, all right, man. So like I've got a couple things going on. So tomorrow we're going to be on no, I'm sorry, on my channel, not Jay's channel, for the beginning of the Ashley Benfield trial, which is the Black Swan trial. You know anything about that one?
Yeah. That's going to be a great one. That's going
So
to be a very interesting case.
I anticipate that we'll be seeing you during the course of that trial whenever you want
I
to
will.
jump.
Yeah.
Always a standing invite, man. Always a
Thank you.
standing invite.
Yeah.
And
I might bug you on that one. Yeah.
yeah, dude, no. And I am happy to dual stream, so it's like
That'll be fun.
however you want to handle it, you're trying to build that channel up, man. So however you want to do with it, but you always have a standing invite to hang with us.
You're the
So
best.
but yeah, that's gonna be tomorrow. Look for that link, set your notifications. Please, if you have not subscribed to Courtroom Confidential over at Josh's channel, it's phenomenal content. Guy's smart as hell, and he's a lot of fun. He's a really bright guy, and he makes things really, really interesting. And make sure you're checking in with us tomorrow. I think it's going to start at probably 8 Central, if it's because it's a Florida case, so it'll be 9 Eastern Daylight Time. I will confirm that though, but if you would be kind enough to hit the like button, the subscribe, share on your way out here, I'd appreciate that as well. And then a couple other things that we got going on. So Jay and I are doing Benefield all day, assuming that they get the jury picked. And then in the evening, I have a very special show, and I'm hoping Steve, and I'm gonna hit up my boys at Publicly Buzz because I know they always do something on Tuesdays, but I had to do this on Tuesday. I have Michael Bryant and the wonderful host of Law and Crime. Have you been on with Michael Bryan over at Law and Crime?
No, sir.
Okay, and Linda Kenny Baden. They're both awesome. They're both great lawyers. They're both hosts over at Law and Crime. They've got their own YouTube channel, and they're going to be joining us tomorrow night just to talk shit, just to go through. Like, they don't get to stretch their legs on Law and Crime. They're beholden to the advertisers and all that stuff, which is what I love about what we do here. We get to talk about anything we want for as long as we want to talk about it.
Yeah.
So that'll be tomorrow night. Make sure you're checking. I think that I have that set for 7 p.m. Central, 7 Eastern. But make sure you're checking your notifications for that. And then I will be doing a live, but it's going to be recorded with Dorsch because that's the Gacy tapes, which I usually run on Tuesday night. So I have a very busy day tomorrow. So be checking for your content. And as always, dude, I love you. Thank you for joining. Make sure, please. I'm gonna go. What's his count? Like, yeah, I need to know. If I always expect our amazing chat and our amazing viewers to come and give the love. I know that everybody who's here all the time has already subbed to you, but if you're new, go sub to my boy. And if you like us, sub to us as well, because we really appreciate it. So, all right, brother, stay in touch. And whenever you want to jump in on Benefield, hang in.
You're the best.
All right, you're the best, buddy.
Thanks again.
All right, man, my pleasure. All right, y'all. Let's see. I'm gonna pull Josh off. Boop. And thank you, mods, for jumping in. I know you guys had double duty over at Jay and then over at here. And we will see you guys tomorrow. Look, Benefield's going to be a good one. It's going to be a good one. It's like Jay's been wanting to do this one, and Jay and I did do the standard ground hearing a long time ago. It seems like it was months and months ago. And then I know that they gave you the primer on it yesterday. So make sure that you're with us tomorrow, bright and early, over on this channel. And then we will be alternating between us and Jay's channel every day, like we do. And just remember, mods, we love you. Thank you so much for all the work you do. And thank you to you guys for hanging with us, because without you guys, we'd just be old bastards talking about a bunch of cases.